Hello, everybody, and welcome back to SEC Roundup. I am Nick Morgan, the co-founder of ICANN, Investor Choice Advocates Network, and the host of today's episode, where we are very pleased to have join us Eric Rosen. Eric is a partner in Dynamis, a white-collar boutique, and formerly was an assistant United States attorney in the Boston United States Attorney's Office. Thank you so much, Eric, for joining us.
Thank you for hosting. I appreciate it.
Ah, I left out of my description of you the
Right.
fact that you represent Andrew Left. Listeners to this podcast will be somewhat familiar with Mr. Left. Um, as most people know, it made quite a big splash, including an article in the New York Times. The SEC and the U.S. Attorney's Office have both brought civil and criminal charges against Mr. Left. And there's been plenty written and said about those cases. Don't want to get too into the weeds, although feel free if
Yeah.
relevant. But instead, what I wanted to talk to you about was what I thought was creative thing that you did fairly recently, and that is to file a petition for rulemaking with the SEC in this area, which this area being people who talk about publicly traded stocks and also trade in those stocks, and the sort of murkiness around, where lines get drawn and what's permissible and what's not permissible, which anyone who's practiced at all in this area understands is not always crystal clear where the lines are.
Yeah.
So maybe you could just give us a little overview. I think you submitted the petition toward the end of January.
Sure.
Why did you and your client do it? What were you trying to address with that?
Well, I think the fundamental issue is, you talk about a stock online as millions and millions of people do, and then when can you trade after that tweet you put out, that Facebook post, that email you sent maybe to a bunch of other people? Like when can you actually trade after that? And the fundamental issue is like, listen, uh, if you want someone to follow the rules, then make a rule. Right now, there is no rule saying wait 1 day, wait 2 days. And one of the unique things about Andrew's case is if you actually go to the SEC complaint and go to the very bottom, the very back of the complaint, one of the things of relief it asks for is a 5 day sort of cooling off period between a tweet, an emoji online, and a trade. You think about how the markets work. It fundamentally doesn't reflect the reality of how, especially in the volatile markets today, of how things, the market volatility, and basically a tweet on Monday could mean nothing by Fridays when you're sort of allowed to trade. And that got us thinking of like, we should just ask them for a rule because everybody wants to follow the rules. Everybody will. Everybody, if you have a clean demarcation of what you're allowed to do,
Right.
then people can have the clarity. Because ultimately, um, you know, this is a First Amendment issue, and it's about a chilling effect that the lack of no rule has on people tweeting, contributing to public discourse. If you are worried that a tweet on Monday will somehow get you on trouble with a trade on Wednesday, maybe you need to pay off a debt, maybe you have to cover a margin call, maybe you have to, you're paying for your kid's wedding
Yeah.
and you had to trade. You still love the stock, but you have to trade out of it. And
Sorry to interrupt, but let me
yeah, of
just pose a
course.
question to kind of see if I can frame it up. And I want to use a fact scenario that's not taken from the case because we'll leave the
Yeah.
litigation. But let's say I'm an influencer, day trader, and I've got a huge following, and I want to make sure I'm talking about the right kind of case that's
Of
addressed in your
course.
petition. So I put out a tweet or post on a website or a YouTube video or something, and I say, hey, I really like this stock XYZ. I'm going to buy a bunch of it. And so I do that. And then your point is 24 hours, 72 hours, a week
Right.
later, I trade in the opposite direction that I was suggesting in my original post. I'm not saying anything false or defamatory
Right.
about the issuer, and I'm not. I don't have access to inside information about the issuer.
Right.
I mean, is that the kind of scenario that your rule petition would seek to address?
Yes, I mean, absolutely. I mean, the biggest issue is, how does the SEC charge this? How does the DOJ charge this? Well, they're saying not that you are required to disclose your trades. You're not. They're saying that your opinion is rendered false by the fact that trades entered after that opinion is released to the public somehow contradict your opinion. And the issue is, well, what if I sell 25% of the of my position? What does that mean I'm contradicting myself? What happens if the stock I tweet stock goes up? I say the stock is looking great. I think it's going to appreciate in the near term or the long term. Stock pops 10% on your tweet. You're an influencer. Why can't you sell then? That was your prediction.
Right.
And you're like, well, listen, I'm a short-term trader anyway. Like, why can't I get in and out of positions without rendering my stock price for, say, Tesla 2 years down the road?
Right.
Why do I have to hold for those 2 years? And that's fundamentally the issue is when is your opinion rendered false by future trading?
And I do think it's interesting. Your rule petition is not suggesting that there be no regulation in this area. To the contrary,
Right,
you're seeking some regulation. So, for example, if the SEC said created a safe harbor, uh,
right,
X amount of hours, days after you publicly announce some kind of trade in this direction, after a certain amount of time, the presumption should work in your favor that you're free to trade after this. So it's
right.
I've got it right, that you're seeking clarification in terms of a creation of some rules in this area.
We're seeking a clarification that comports with the First Amendment because fundamentally, the fact that there is no rule has a real chilling effect on what people are going to say,
Yeah,
or the fact that they're not going to say anything at all. And that's the issue is like, why would you say anything if a trade 3 days later can get you indicted, can get you thrown in jail, even though your fundamental issue, what you were saying about the stock was true. It's these amorphous lack of standards that does it. And fundamentally, like, fine, say you can't trade for one day after your tweet. If someone wants to challenge that as a First Amendment violation, then they can do that. But we need something to challenge. We need something to give people certainty that what they're doing is good, or what they're doing is going to attract regulators' attention.
right. Well, I like the rule petition. We're always in favor of clarity, particularly when
Right.
clarity protects investors. So good luck, and keep us posted on the rule petition. And I guess in the meantime, we'll keep an eye on the two underlying pieces of litigation and see how those turn out. But Eric, hey, thanks very much for taking the time to
Thank
come
you.
on.
Thanks,
Everybody
Nick.
else, thank you. Everybody else, if you want to find out more information about ICANN, go to icanlaw.org, and we'll see you on the next SEC Roundup.
Thank you.